All right, the Senate Committee on General Laws will come to order. We'll begin as a subcommittee and then to begin with bill hearings. And so we'll start with Senate Bills number 661 and 648 at the same time. And I will turn the committee over to the Vice Chairman here for a moment while we present these bills.
All right, bills this morning. First up, we got Senate Bill 648 and Senate Bill 661, sponsored by the chairman, Senator Trent, and Senator Brian Williams. Bright item, bushy-tailed, 8 a.m. Let's go. Give it your best shot. Thanks for being here.
All right, thank you, Mr. Chair, committee, subcommittee, for hearing Senate Bill 661. Basically what it is, it's a bill that doesn't allow a ban on artists using creative expression in criminal cases. We've seen that there's been instances all over the country where artists express themselves, utilize their First Amendment right, and that's been used to try to incriminate them in criminal cases. What we want to do is uphold the Constitution, make sure that the criminal justice system is working appropriately and not using artistic expression as a way to incriminate someone for a crime that they did not commit. We've noticed all over the country that we've seen several cases where there's been highly prejudice and discriminatory attempts to try to conflate taste in art and music with bad character. These cases have been overturned after convictions that have been done in red and blue states all across the country, ranging from Texas, Georgia, Tennessee, Maryland, and California. We've also seen prosecutors conduct training at annual membership conferences on how to deploy this practice, and it's only growing and becoming more reaching. It covers all types of creative expression, including painting, literature, poetry, and so on. It protects all artists, including artists from Missouri, like Chal Perone, Sheryl Crow, Nelly, Sarah Evans, Brad Pitt, Gillian Flynn, so many different artists, and clearly my favorite artist, Justin Bieber. This is important because freedom of expression is a constitutionally protected right. Moreover, we also know that children are smart, including my adorable 2-year-old. They have common sense, and art is not a literal confession. So every parent of a child encourages them to use their imagination when they hand them paper and crayons. And we want to continue to be able to do that with the current generation of artists as well as future ones. So with that, there's been several notable cases in Missouri where we've seen folks been either accused, convicted of crimes, and been used because of lyrics or things that they have expressed as an artist that was not relevant to the case. So with that, I'll allow Senator Trent if he has some things he want to add to it. But bottom line, we want to focus on protecting the First Amendment right, upholding the Constitution, ensuring that artists can express themselves and not be incriminated or accused of crimes that they did not commit.
Thank you to my colleague for that explanation. The only thing I would add is that there is a mechanism by which expression can be admitted to the court under a clear and convincing evidence standard 4-factor test. That if there's expression is original and the defendant intended a literal meaning rather than a figurative or fictional meaning, or in a derivative expression that the defendant intended to adopt the literal meaning of the expression. 2, that the creative expression refers to specific facts of the crime alleged. 3, that the expression is relevant to an issue of fact that is disputed. And 4, that the expression has distinct probative value not provided by other admissible evidence. Then a statement can be brought in. That's a very high standard. And would essentially require, I think probably an instance where someone wrote a true crime book and it was literally the true crime that they had committed. We would still want to be able to bring that in, and I think that this would allow for that and strike that right balance between a high standard of protection of expression and still allowing probative evidence to be admitted to a case where there were some legitimate reason to do so. Although I think that would probably be exceedingly rare, because typically folks don't use their creative expression to admit to crimes. With that, I'd be happy to answer any questions the committee has.
All right, so if I picked up anything from that testimony, it's the senator from the 14th had Bieber fever at one time. Did I understand that correctly?
Strong tie between him and Taylor Swift.
Okay, all right, just wanted to clear that up. All right, any
Taylor's
questions?
kinda leading right now.
A little bit. Any questions from the other committee member that's present? Thank you for that, Senator. All right, we'll go witnesses in favor of, and roll through in favor and then opposition. So first witness in favor of the legislation, please come forward. Don't forget to fill out a witness testimony form and proceed when you're ready.
Good morning, Chair and committee members. My name is Brandon Harrelson. I am the Director of Public Policy and Government Affairs for Arts KC, the Regional Arts Council, and my remarks are not loading. This is why you shouldn't rely solely on technology. There we go. Okay. I'm also a lifelong artist and a singer and actor by training. I earned my bachelor's degree from UMKC Conservatory in 2013 and my master's from the University of Northern Iowa in 2015, both in voice performance. Here today to speak in support of Senate Bill 648 and 661, which aim to protect freedom of artistic expression as guaranteed by the First Amendment of the Constitution of the United States of America. As someone who was born and raised in rural Southwest Missouri and has also called Kansas City home since I was 18, I can tell you with confidence this issue is one of the few remaining where people from all sides of the ideological spectrum find agreement. Regardless of our background or lived experience, artistic expression is part of who we are. It's how we tell our stories and share in our common humanity. It builds understanding, and we cannot allow it to ever be weaponized against us. My grandfather, David, was the athletic director, vice principal, and yes, also the music teacher of my same rural school district a generation before me. He was also a fervent believer that a person's God-given artistic talent should be supported and nurtured. That belief, rooted in faith and fairness, continues to guide me today and informs my resolute support of this legislation. In addition to my work with Arts KC, I also serve on the board of the Midwest Innocence Project, where I see firsthand how misinterpretation and bias can lead to disastrous and regrettable consequences in the criminal justice system. Consider that if someone in your own family found themselves a defendant in a criminal case, would you want their work or their Spotify playlists, Netflix watch history, or video game history used against them as evidence of moral failure or criminal intent? Who among us has not delighted at the latest episode of Game of Thrones or Ozark, or lost ourselves in a few hours of playing Call of Duty? I'm sure that none of us would want our media diet used against us as evidence or leverage to draw unjust and flawed assumptions. To that end, I reiterate my fervent support for SB 648 and 661. These bills help draw a firm line between art and action, between what we imagine and what we do, and they not only protect artists and creatives, but all Missourians from misjudgment. Thank you for your time, your thoughtful consideration of this legislation, and for your support of creative freedom in our state, and I'm also happy to take any questions you might have.
All right, and I have to ask a question. Is there not a point in time in which maybe something crosses a line? And then, let's say there is a song written, and then a crime happens. And I don't necessarily know how the criminal code works, but I've heard premeditated murder before. And the premeditation comes from a song that was written.
Mm-hmm. Well, first of all, I would fall back to the Constitution, First Amendment. What are we allowed to say? What are we not allowed to say? But also, I think that's one of the best parts about this legislation is there's provisions that allow for the 4-point check for admissibility through a reasoned and self-evident manner. And I think that, for me, is not a blanket excuse or a blanket forgiveness of all expression, regardless of if there's any malice or direct affiliation to the crime that was committed. And I think this 4-point check system that's allowed, if they want to admit it, is a reasonable compromise.
All right, thank you.
Yep.
Any questions from the senator from Newton? All right, thank you. Next witness in favor of the legislation.
Good morning, Chairman and distinguished members of the committee. Thank you for the opportunity to speak today. I'm Ron Gubitz. I am the Executive Director of the Music Artists Coalition. I'm a resident of Olivet, Missouri, and I'm proud of our state's rich artistic heritage. Missouri is, as we've heard names here earlier, has given the world creative treasures like T.S. Eliot, Tennessee Williams, and Chuck Berry, artists who have shaped American culture. The Music Artists Coalition is an organization dedicated to advocating for the rights of music creators. Our mission is to fight for the livelihood and autonomy of artists at all levels, ensuring that they have a seat at the table when decisions affecting their careers and their lives are made. MAC was founded by industry leaders including Irving Azoff, longtime manager of the Eagles, artists like Dave Matthews, Anderson .Paak, Bonnie Raitt, Don Henley, and Billie Eilish. Big name and small name artists across all genres who believe creators should drive that conversation about those issues shaping their lives. I'm here to express strong support for the Restoring Artistic Protection Act, which establishes reasonable standards to protect creative expression while maintaining public safety. In recent years, as has been mentioned, we've witnessed this troubling trend of prosecutors using artistic expression as literal evidence in criminal proceedings, and this misunderstands fundamentally how art works and threatens our First Amendment freedoms. A concrete example from here in Missouri would be with Chuck Berry in his 1955 hit, "Oh Maybelline." He sang about racing a Cadillac at 110 miles per hour. Under current standards, if Berry were charged with reckless driving, prosecutors could present these clearly figurative lyrics as evidence of his speeding. This isn't hypothetical. Just recently, courts in Georgia, Texas, and Tennessee have overturned convictions because creative expression was improperly admitted as evidence. So while hip-hop artists have been disproportionately targeted, this does threaten all creative fields. These bills are not a ban. It simply creates a common sense test or rubric for when creative expression can be admitted as evidence, including whether the work is figurative or literal, and if there's a specific fact pattern matching the allegations. If Chuck Berry were to be charged with racing someone named Maybelline at 110 miles per hour, that would be admissible. As the song is written, it is figurative. This bipartisan legislation balances protecting artistic expression while maintaining public safety. Similar bills are gaining support across the country, but let's continue to lead here in Missouri. Our creative economy generates $11.5 billion in annual GDP and supports 94,000 jobs across the state. But beyond economics, this is about our fundamental liberties, freedom of speech and freedom of creative expression. So I urge you to support this bill and show America that in the Show Me State, we stand for artistic freedom and the First Amendment.
All right, thank you, sir. What was the name of that song? I'm going to have to look it up because one of my favorite classic rock songs is Hot Rod Lincoln by Commander Cody. And I happen to have a Lincoln, so I wouldn't want to get in trouble if I'm driving like a hot rod. So what's the name of that song so I can listen to it?
Yeah. You're more than what you said. Can you listen to it?
The name of the Chuck Berry song.
Oh, Maybelline.
Okay.
Yes.
All right, thank you.
Yeah.
Any questions from the committee? All right, thank you, sir.
Thank you.
Next witness in favor.
Good morning. Tashayla Person, registered lobbyist on behalf of Free Arts Coalition. It's an organization representing the artistic community, both recording academies, songwriters, actors, and literary groups. They are dedicated to advancing the First Amendment of creative freedoms, and we just want to go on record for support of the bill and thank the sponsors for the work.
All right, thank you for your testimony. Questions? Seeing none. Next witness in favor, please proceed when you're ready.
Mr. Chairman, members of the committee, Kaina Iman on behalf of Missouri Citizens for the Arts. We'd like to go on record in support of both Senate Bill 641 and 648 and appreciate the sponsors bringing this forward.
Thank you for your testimony. Any questions? Seeing none. Thank you. Any other witnesses in favor of the legislation? All right. Seeing none. Witnesses in opposition? Come on up. And as I said before, make sure you got a witness form filled out and proceed when you're ready.
I am a poor substitute for an actual prosecutor, but I'll do the best I can today. My name is Ward Cook, testifying on behalf of the Missouri Prosecutors Association. I just want to make a few points. Senator Trent was correct. There are mechanisms to allow evidence or disallow evidence in pre-trial litigation. So I wanted to reiterate that was a good point. But evidence against a defendant usually goes to the motive, general motive. I'm sucking. We really are concerned about the motive and the intent of this legislation. We're not trying to get at the actual act of the artistic expression. We're looking at the motive and the intent. If it specifically says, I'm going to go kill somebody, and then they go and create and actually do that act, that's what we're concerned with. If someone goes and makes a artistic song or a art or something, and it specifically directs to the motive or the intent of the crime, that's what we're concerned with. So that's what we wanted to get on record and testify against on this bill. Hopefully, we've tried to think of a way that we can kind of compromise on this language, but unfortunately, we don't see a way that we can do it. So I'm open to any questions.
All right, thank you.
Sorry that
I thought you
totally sucked.
You
but
did
I
okay.
the best
You did
I could
okay in my book.
on a short term.
That's all right. Any questions?
Yeah, I just have a question. So Senator Trent has said that would be addressed. Those concerns would be addressed. Are they not addressed?
So according to my prosecutors, there are ways that you can have admissibility in pretrial cases, but they still oppose the bill because they believe that they're concerned about being able to to qualify certain song lyrics, especially in the motive and intent of a song lyric in a case, and making sure that's admissible in cases.
Okay, thank you. Senator Trent, would you please speak to that?
Yeah, so it sounds like the concern here is that perhaps the way it's drafted now, you'd have to show that the expression, if original or derivative, either one, that a literal meaning is necessary. And so I guess the concerns, I understand it, and happy to have this conversation more extensively than is permitted by this format, is that you could be speaking figuratively about committing a crime and then go out and commit an actual crime that the figurative meaning alluded to. I think that while I understand that concern, I think that that's very difficult to legislate around in this instance here, because what we're trying to get at is when someone is engaged in creative speech, that is not like whatever happened later, like that figurative speech is not related to whatever literal crime may or may not have occurred. And so I would be happy to try to address that concern, but it may be that these two goals are just in opposition to each other, and I believe that we should that we should give maximum deference to speech, and also in any criminal case, I think we want to protect the rights of the accused first and foremost in our system as the way it has been constituted since the foundations of the country.
So in regards to, and this is just I don't understand a lot of the complexities of this, but it's already, so how do you have clear delineation between somebody coming into a movie theater and yelling fire, right? Or, I mean, at some points in our law, there is responsibility for actions that are taken by using words. So where's the delineation between creative expression and responsibility for actions?
Well, so in the instance where someone falsely yells fire, and then you have a riot in a movie theater and people are injured, the words are the action that caused the harm. In this case, the words have not caused any harm. There's simply an attempt to use the words to prove state of mind or motive in other actions that took place independently, and that it can be a very tenuous linkage between the harmless words that were figurative, that were fictional, and some actual occurrence that happened, and so.
And in most of those cases, it is the person that's responsible for saying the words that gets in this creative realm. You're saying that if a singer or an artist is the one who says the words, they are the ones that are responsible for an action that is perceived that they committed.
Right, but the word. So if if the author of a detective mystery were on trial for a murder, the fictional works that they had penned about committing murders have no relationship to the murder that they're accused of committing, unless, in fact, and that's what the four-factor test is designed to do, the nature of those words so closely mirror the fact pattern of the case that's being brought against them that you could say that this was not in fact a work of fiction, but was in fact a plan or a admission that occurred in the guise of literary fiction.
Interesting. And then the prosecutors have a concern with that.
Yeah, I mean, they certainly, I'll let them speak for themselves, but certainly this would narrow the admissibility of that type of evidence from the standard in which it's admissible now.
Okay, thank you.
Senator Williams, you want to comment also?
Yeah, I just think that we need to get back to the point, and the point is that it's not a ban on creative expression in criminal cases. What it's doing is a common sense limitation to curb the growing abusive practices that we've seen against First Amendment right protections. And what it does is it tries to attempt to conflate taste in art or music with bad character. And I think about so many different artists that say things, and it's art. And we have to be careful with this, because this is not just exclusive to music. This is also all types of creative expression, painting, literature, poetry, and so on. So this is not just about using words. This is about people expressing themselves and being able to do that and not have their constitutional rights violated.
All right, thank you. You got any closing comments, or you good? Well, you're up here, so I'll allow this one time, and then we'll move on to the next witness.
Well, I appreciate your honesty and talking about this openly. I don't think anybody in the room wants to try to restrict the fact that if someone says in a song, "I'm going to go kill, Senator Gregory," and then 2 weeks later goes and kills Senator Gregory. I don't think but at the same time, restricting that admissibility in court is not something anybody wants. In my opinion, that's not something anybody would really want to do, because we want to make sure that those words are admissible in court. So I think that's what we're afraid of, that motive, intent, and narrowing the scope of what is admissible in court is problematic for the prosecutors.
All right, thank you.
So,
Thankfully,
thank
there's
you.
two Senator Gregors. They'd have to make a choice. All right, next witness in opposition, please, or anyone else in opposition. All right, seeing none. Anyone for informational purposes only? Also, seeing none. Gentlemen, any closing remarks, or we got it covered?
Well, I would say that I think in the example just proffered, the bill would allow admissibility of that kind of statement.
I'm glad to
Where it
hear
was
that.
Closely followed by action. I think their concern is perhaps more tenuous connections, but we'll be happy to work with anyone on further refining the language as we go through the process.
Yeah, and I'll close with what this bill does is just put lyrics out of bound initially, but create a clear path to bring them back in for rare cases where someone's crazy or stupid enough to say something and actually do it.
All right, thank you, senators. Let's see, 570. Mr. Chair, which would you like to roll to next? I know, they'd have to make a tough choice. Okay. 834, you got it.
All right, we will next begin public hearing for House Bill number 834. Representative Farnan, please proceed when ready.
Good morning, Mr. Chair and member. I'm Jeff Farnan from District 1 in Northwest Missouri, and today I'm bringing to you House Bill 834. This bill modifies the process of obtaining a license to practice embalming and funeral directing by allowing an apprenticeship program. Every applicant must complete a funeral or embalming education program and pass all boards required. After that, they get a provisional license where embalmers must complete at least 25 embalmings under an apprenticeship program within 6 months, and funeral directors must complete at least 10 funeral service under supervision within 24 months. All requirements for this are laid out in the bill. On the floor in the House, this was amended. There was 2 amendments to this. I want to explain those briefly. The first one pertains to an emergency suspension or restriction of a license for a massage therapist or a chiropractor if the licensee is the subject of a pending criminal indictment and there is reasonable cause to believe that the public health, safety, or welfare is at imminent risk of harm. The second amendment, this amendment allows to get an individual to get a master's degree from a social work program in pre-candidacy for accreditation that is recognized and approved by the Committee for Social Workers. So I'd be happy to take any questions.
Questions for the bill sponsor from the committee? Seeing none. Thank you for that presentation. Witnesses here to testify in support. Please make sure you fill out a witness card and proceed when ready.
When you get here soon enough. My name's Don Otto. I'm the Executive Director and General Counsel of Missouri Funeral Directors and Embalmers Association, and as you probably know, we support this bill very strongly. It's the funeral director part of this is identical to Senate Bill 351. And what it does, it's really a workforce development bill when you think about it, because it clarifies and removes unnecessary roadblocks for people entering the funeral directing or embalming profession. We worked very closely with the State Board of Embalmers and Funeral Directors on this. We had a similar bill last year that almost made it through. It was last week a session, didn't quite get high up on the calendar before everybody adjourned. And so we're really urging that we get this through this year. Although they were under no obligation to do so, I'm pleased to say that the folks who amended the bill on the House side did approach us first to make sure we didn't have any problems with those amendments. And it has nothing to do with the Funeral Directors Association, but I read them and they both look like pretty darn good ideas to me. So I appreciate that the representatives did that. That was a very nice thing to do. And again, I'm open to any questions that anyone has.
Questions for this witness from the committee? Seeing none, thank you again for being here. Further witnesses testify in support? Seeing none, any witnesses here testify in opposition? Seeing one, please proceed when ready.
Lisa Panette with Armor Vine. Let's see here. This bill is calling for the board to restrict or suspend a license. And I just want it on the record that some of our best doctors in the state are currently under investigation because of the protocols that they chose during COVID, including using medications off-label. So this could be potentially weaponized against the best doctors in the state. This is also referenced under 331.084 if there's a reasonable cause for the board to believe that the public health, safety, or welfare is at imminent risk of harm from the holder of the license. These are the same broad terms that were used to weaponize COVID. As far as the funeral portion of this bill, you're making it more difficult for students to study under directors. In the current law, they're enrolled in a program and they fill out a form by the board, and then the student assists. These changes now would have to be approved by the board. So help me understand why, when we're deficit of occupations, that this body would make it actually harder to get students to study under these directors. On page 6, it has a new addition that the person wanting to receive an embalming license must sit for a national board administered by the International Conference of Funeral Service Exam Boards. The family funeral homes are being usurped and replaced by corporations, and I see this as nothing more as an expansion of that under an international guise and guidance. And with that, I'll take any questions.
Questions for this witness from the committee? Seeing none, thank you for being here. Further witnesses testify in opposition? Seeing none, are there any witnesses here to testify for informational purposes only? Seeing none, that will conclude the public hearing on House Bill number 834. All right, we will stand at ease here just for a second as we attempt to rustle up either some more committee members or some more bill sponsors. Quorum in a reasonable time frame, and we will have the public hearing for Senate Bill number 717 while we await for that time.
All right, as the chair said, I think he needs to take at least 15 or 20 minutes to present this bill. Maybe we'll have lots of questions. Senator, Mr. Chairman, Senate Bill 717, please proceed when you're ready.
All right, thank you, Mr. Chairman, members of the committee. Curtis Trent, representing Senate District 20. This is, if you look through the bill, there's not a lot of language here. This is removal of Missouri Human Rights Act attorney fee provisions for public entities, and the rationale for this is both the number of cases and the amount of dollars that are being expended from the fund for the basis of these lawsuits. If you look at the expenditures, the total dollars spent on MHRA-related expenditures has steadily risen each year. Stats for FY25 suggest a slight rise this year, or similar figures to last year in total MHRA expenditures. The percentage of LEF funds spent specifically, that's the legal fund for the state that's spent on these cases, is on track to exceed 60% of all expenditures by the end of this fiscal year. Attorney fee payouts have steadily risen each year. This year is probably going to have a slight decline or remain steady. But in FY24, attorney fee payouts on MHRA cases made up close to 80% of all the MHRA expenditures. And so if this doesn't change, attorney's fees will likely make up 50 to 80% of all MHRA-related payouts, or approximately 30% of all legal fund expenditures going forward, which is just a really unbelievable amount of expense that the state legal expense fund is having to bear. And in many cases, you have attorney's fees that are exceeding the dollar amount, and you can easily come up with a hypothetical that would illustrate this, that the attorney's fees are exceeding the payout of the object of the case, like the actual damages and punitives that are being paid out in the case, which is I think probably an unintended side effect of the way that the statute is written now. So we'd be happy to answer any questions. I believe we do have a couple of witnesses here that will testify on this, but happy to answer any questions from the committee.
All right, will the witnesses in favor come up, fill out a witness form, and please proceed when you're ready.
Good morning, Senators. Good morning, Committee. Dan Engelman here with the Attorney General's Office, Director of Policy, and keeping with the theme of pinch hitting. So you got a pinch hitter this morning. I'm certainly not a subject matter expert, but I'll do my best as we're covering other hearings this morning. But Senator, we appreciate the Senator bringing this forward. Did a great job explaining it. Just to add a little bit to it, just in general, plaintiffs' counsel are getting paid out with taxpayer funds and LEF, as he mentioned, legal expense fund. So the AGO is often settling or defending these MHRA suits, often for a fraction of what the plaintiffs are requesting, which saves the state millions on the front end. So, for example, if we get a judgment of $10,000 in a $2 million suit, that's a huge win in our minds, but they can still request legal fees for all the time spent, even if they win on only 1 out of 10 grounds. This statute has no barriers, so what we're trying to accomplish here. Unlike many other statutes that govern attorney's fees, the courts will add a multiplier to make these cases even more lucrative. General Assembly, to your all's credit, you made a conscious effort to reduce wasteful spending. This is another example of excessive, unnecessary spending. The Senator mentioned the fiscal note. We anticipate savings totaling at or above $10 million in the legal expense fund, and would free up about 4 to 5 attorneys to work on other things. Happy to take any questions.
Seeing none, gentlemen, thank you for your testimony. Any other witnesses in favor of Senate Bill 717? Any witnesses in opposition? Senate Bill 717. Fill out a witness form. Proceed when ready.
Good morning. My name is Eric Plater. I'm a civil rights lawyer on the Kansas City side of the state and have been involved in a number of cases involving violations of the Missouri Human Rights Act against state entities, including Department of Corrections, Division of Youth Services. First of all, to characterize what we're talking about as being wasteful spending is it's totally a mischaracterization of what we're talking about. The statute provides that there's a fee shift. If the plaintiff is the prevailing party, and only if the plaintiff is the prevailing party after going to trial, is there any implication that fees are generated for the plaintiff's lawyer. So what that means is the state will have required us to litigate it all the way up to a trial. We will have had to prove the case on behalf of our clients at trial to a jury of 12 people. And then and only then can we make an application for attorney's fees. The idea that like they're settling cases for attorney's fees, it just doesn't happen because you're not entitled to attorney's fees until you're actually the prevailing party. What kinds of cases are we talking about? We're talking about cases. I'll give you an example. In reports that have been produced by the state, their own internal investigations into what happened, here's some of the cases we're talking about. One corrections officer, male corrections officers, toward female corrections officers saying things like, "Your tits are fake. Are yours?" to another one. "They are so big you probably can't even run or they'll be bouncing in your face." Or to another one, "Brian, you need to get laid. Gallego will fuck you. Won't you, Gallego? You'll fuck him. I'd rather fuck her. You probably need
Gentlemen,
a small
can you
guy."
please go ahead and refrain from using that language? I know it's in court, but
All
just for sake of the committee, thank you.
Here's the point. In cases against the state, the Attorney General has to defend the state. Private people like me, private lawyers like me and Mr. Jess and others who may testify, we operate as private attorneys general for state workers who are subject to this kind of behavior. They can't do it. The Attorney General can't take the case. They have to defend the state. And so there has to be an incentive for people who know how these cases work, who know how to navigate, who know how to litigate against the largest law firm in the state of Missouri, which is the Attorney General's office. There has to be an incentive. Otherwise, if a person comes to my office or some other lawyer's office and says, "Hey, these things happened to me in the workplace. What am I supposed to do? I don't really know what my damages are. There's no way for us to recover any amount of money or to be compensated for what's happened to me." And if they assign multiple lawyers and I need help on the case, how am I going to help the citizens of this state win cases where their constitutional right against being discriminated against has been violated? There has to be that kind of shift. And so, in my opinion, there's no reason why the state specifically, those cases covered by the Legal Expense Fund, should get any exception to any other employer or any other state subdivision. What they're doing is they're forcing us to take these cases to trial, cases that are dead losers for them. They're making us do it, and now they're complaining about having to pay our fees when that's what every other employer has to do. And there are other protections already in place. I'll just give you some examples and then I'll be finished. First of all, the state only pays it pays itself back 50% of every punitive damages dollar that's awarded. It goes from the Legal Expense Fund to the Tort Victims Compensation Fund. That happens in every single case, even against private entities. Private entities pay into the Legal Expense Fund, so they're never fully on the hook for the damages that are awarded. Second of all, there are caps. Senate Bill 43 that was passed in 2017. There are now caps on damages for folks who are subject to these types of claims. It is true, sometimes the attorney's fee award outsize the actual award. Are there one-offs? Of course there are one-offs. But there are usually, the general rule is, first of all, you have to win anyway before you're even entitled to attorney's fees. But once that's done, it's not even like you just get what you ask for. We have to submit an application to the judge. The judge has to decide, is the fee that you've asked for reasonable? We usually have to have supporting affidavits from other lawyers. They can cut our time. They can cut our requested fee. It's not like a matter of you win and then you're just asking for a bunch of money. That's just not the way it works. And there's no reason why the state should be exempt from the same laws that apply to every other employer. I'm happy to answer any questions about these types of cases, about how it works, because in the end, it's going to be difficult for the individual workers who work for the state to get lawyers in instances where we're talking about behavior like I've described. And without those types of protections, people are just going to be working in an environment where they're not going to be able to get a recovery.
All right, gentlemen, thank you for your testimony and the work that you do. Any questions? All right, seeing none, thank you, sir. Next witness in opposition.
Thank you, sir. Sorry, Senator, I'm going to put that down. I apologize. I drove up from Marshfield, Missouri.
And I know your voice carries extremely well, sir. Can you make sure that microphone's turned on so it picks up? It looks like it's green light is not on.
I believe it's on.
Okay.
From here, hear me, sir?
I can hear you just fine. It just didn't look like it's on from here. All right, proceed.
Oh, it says green, so, but I'm not good with technology. I drove up from Marshfield, Missouri this morning. I got a case in Springfield, but my name is Mark Jess. I used to be a partner at Bryan Cave Law Firm, headed up the Labor and Employment Department in Kansas City for years, and then opened my own firm, Employee Rights Law Firm. And here's my question about this bill. And with all due respect to Senator Trent, whom I do admire, and I believe he represents my kinfolk, because I live in Platte County now. But here's the problem. Why are we singling out one section of state employees to not have the protections that every private sector employee has and city employees have? For example, let me tell you about two cases that I had, and I'm not going to curse, although I often do. And he was quoting court testimony, so it wasn't Eric's fault. But here's the deal. The latest one, I represented a firefighter who worked for the Kansas City Fire Department. And they went through this process where they're trying to decide who's going to get promoted to be deputy chief of the fire department. They decided that it was unfair that there was a writing requirement because somehow that left out African American folks. Now, I don't believe that, but they did. And so he was the most qualified. And what happened was they chose an unqualified person for that position, such that the union had to step in and say, hey, we're going to have to cover this guy because he can't protect our citizens or his fellow firefighters. So my guy, because he was white, didn't get the job. Well, he came to us and we got a settlement on his behalf. Not an attorney fee award, a settlement. But why would we as citizens of the state of Missouri, don't we want the best and the brightest working for our state agencies? Why would we try and take away their rights? It doesn't make any sense. The other case I'll tell you about, again, versus the city of Kansas City, went all the way to the Missouri Supreme Court, right across the street here. Melissa Howard versus city of Kansas City. She was one of 3 people that were chosen under the Missouri court plan to be nominated for a municipal judgeship in the city of Kansas City. The city council put it straight out on video. Oh, we're not going to consider these ladies because they're all white. Well, the jury in Platte County and eventually the Missouri Supreme Court said, no, that's wrong. So my question is, why in the world would we want to take away the opportunity for our state employees to have the best representation they can have? It doesn't make any sense. So I respectfully disagree with the senator, whom again, I drove up from Marshfield and you represent my kinfolk. But I respectfully disagree with you, sir. I'd be happy to answer any questions.
Well, that's the beauty about this building. We can respectfully disagree and still get along at the end of the day. Any questions for this witness? All right, seeing none, gentlemen, thanks for coming up today. Thanks for your testimony.
Thank you.
Any further witnesses in opposition? Anyone for informational purposes? All right, Senator, Mr. Chairman, any closing comments?
No, I would only add that certainly folks will still be able to be represented. Certainly attorneys will still be able to be paid, just not through the mechanism that is available now, where you see some of these overpayments where the attorney's fees outstrip the actual cost of litigation at taxpayer expense, the taxpayer is also an innocent party in these kinds of cases as well. So we're just trying to strike the right balance here. But appreciate the committee's consideration and opportunity to present the bill today.
All right, thank you, sir. All right, next up we'll go to Senate Bill 663, sponsored by Senator Brattin. Senator, make yourself comfortable. Proceed when you're ready. I'll be turning it back over to the rightful chair.
All right. Thank you, Mr. Chair. Members of the committee, for the record, Senator Rick Brattin, 31st Senate District, Cass, Johnson, and Bates County. Senate Bill 663 is something that was brought to my attention. I'm the chair of the Capitol Security Joint Committee, and honestly, it was brought to my attention just with the security aspect. Not so much from our chamber, but when I went out to Washington, D.C., I was with my friend Congressman Onder for his inauguration and a swearing-in ceremony. And one thing that was brought to my attention was in Washington, D.C., all the spouses, all the children of all the congressmen in Washington receive not only badges for entry into the Capitol building and to their office buildings, but they also even receive pins for the spouses to be able to wear while they're in D.C. So I bring that back to our Capitol security and entry to this building. Why on earth we have spouses, we have kids that come up and they have to go through, if they're not with us, they have to go through the public entry. So I just thought this was a common sense deal for us getting entry badges for our spouses and our children to ensure that they're able to enter just as we're able to enter into this building. This is a bipartisan bill. This isn't partisan. There's a Democrat member in the House that's actually sponsored this legislation as well. So hopefully this is pretty non-controversial, and I think is a common sense solution for our families to be able to gain entry into the people's building. So I'm not going to belabor the point. I appreciate you having the hearing, Mr. Chairman, and look forward to your questions.
Questions for the bill sponsor? Senator, please proceed.
Senator Brattin, you know that my son is often up here with
Yes.
me and does school online just so we have that flexibility, but he has oftentimes been locked out of the building. When he goes into activities around Jefferson City and does some things with friends, comes back 6 o'clock at night when the building's locked down. You know, he's had no way to get in. So I really appreciate you. Several situations have happened, is what I mean to say, where he's not been able to get in. We've had to leave to go down and get him. So I appreciate this legislation.
I think all of us have had family that have come, and we've been on the floor offering an amendment. Like I've had family come up, my wife and my daughter and of my 5 kids, the 2 youngest came, and they were having to wait for someone to come down to let them in. And I mean, it was just a nightmare, honestly. And it's happened numerous times. And I just think we can simplify this pretty easy and alleviate that sort of concern. So
Yeah, thank you very much.
Thank you.
Any further questions for the bill sponsor? Yes, proceed.
I'll just echo comments. I feel like this is something that came up at some point in time in my last 4 years on budget in the House. Now House Budget Chairman was trying to bring people in through the parking garage. That was his family, and they wouldn't allow that. So I think this is, I like it. I'll play a little bit of devil's advocate on, is there any way to make sure that it's just going to family members and not friends or buddies or anything like that? Or how do we make sure we cover
Well, I mean,
those bases?
it basically states it does go to the, our spouses. I mean, there's nothing, I mean, we could, I guess, potentially give away our badge and give it to somebody else, but I mean, nothing's going to stop from that, but I would assume that this would be kept on your person, and that's why it's narrowly tailored to family and spouse.
Yeah, absolutely. I like it. Thank you.
Yeah, thank you.
Any further questions? Seeing none. Any witnesses here to testify in support? Seeing none. Any witnesses here to testify in opposition? Seeing none. Any witnesses here for informational purposes only?
Mr. Chair, you think this is a consent bill, potentially?
I believe the time for consent has passed.
Oh, darn.
Otherwise,
Okay.
it might be. But yes,
We'll
I
just do a
believe
consent
that.
the old-fashioned way.
Yes, I believe that time has unfortunately expired. Any further comments? Any closing to the bill?
Well, I was going to say my family's here, but they're unfortunately locked out of the building to come.
Unable to testify.
Thank you, Mr. Chairman.
Thank you. That will conclude the public hearing on Senate Bill number 663. We will again stand at ease for just a moment. We'll resume the hearing. Madam Secretary, please call the roll.
Senators Trent,
Here.
Gregory, Carter, Beck, Bernsketter, Coleman, McCreary, Weber.
We have established a quorum, and with no further business coming before the committee, I make a motion that we adjourn. Do I have a second? It's been seconded. All those in favor, please signify by saying aye. Any opposed to the contrary? The ayes appear to have it. The ayes do have it. The committee is adjourned.